Good afternoon, everybody. My name is Chris Justice. I am an associate with Samfiru Tumarkin. I work out of the firm's Toronto offices, and as has happened in the past, I'm here again to join you all to hopefully answer as many questions that you have regarding employment, everything employment. So could be questions regarding some thoughts or ideas you've had or have going into an employment relationship. Maybe you're wondering about a contract that's been offered to you and whether you should sign it or having questions around that. Maybe you're already with the company in question and you're going through some sort of issue, we'll say mid-tenure during your employment. So any questions regarding that, or perhaps you have a question on your way out or having left a company. So as I say, anything employment law related, get your questions in today, and I'll, as I do always, try to answer as many as I can. Having said that, as many of you may know, I start off the session with a couple topics up front. So one topic I was going to raise today had to do with, or has to do with, continued layoffs, continued trend of terminations across various industries. I know a lot of people in the tech industry are being affected, but really a lot of industries across the board are being affected, and a lot of layoffs are occurring. So I figure it's always a good time just to remind people that if you are somebody who's been laid off or maybe anticipates being laid off in the near future regarding the company you're at right now, there is a good chance that whatever you are offered as far as a severance package is not going to be sufficient. It may look like it's sufficient. It may look pretty good to you, but the vast majority of cases, there is a deficiency in the package that's being offered. So you want to give us a shout if you've been offered a package. First and foremost, just to make sure that what is offered is fair, and if not, what your options are in terms of getting more compensation. There are a lot of things that employment lawyers, such as those at Samfiru Tumarkin, can offer to somebody who's been let go. A skilled employment lawyer, for example, is going to know how much severance is owed to you, whether it's upwards of 2 years or more or something less. An employment lawyer is going to know whether or not there may be other factors at play when it comes to your termination. So, for example, you may not only have been terminated, but you may have been terminated while off on a maternity leave or while off on a disability leave. So there could, as I say, be other considerations that factor into, whether or not it's just a case about severance, or if in fact there's more money on the table that you can go after. And then employment lawyers are also going to know how to best secure a package for you, because a lot of times there can be protracted negotiations, protracted litigation, and employers, or at least a skilled employment lawyer, is going to know whether or not a lawsuit is worth your time and energy, or whether it's in your best interest to resolve your case sooner rather than later. So again, if you're somebody who's been affected by some of the more recent layoffs that have occurred sort of industry-wide, give us a call and we'll be happy to talk further about your case and let you know what your options are and what recourse you have. Sort of related to this trend of layoffs, terminations, there's this new phrase that's been appearing in the media known as career cushioning. And essentially what this refers to is where, an employee who may be worried about losing their job or may fear that their job in some way is in jeopardy, that employee is going to start maybe looking at other opportunities out there, so that when, or if and when it comes time that their employment at their current employer is over, they may have something else lined up. They may have something in the works, so that they're not in a situation where they've lost their job and are now having to scramble to find another job, which could take several months, if not years. So as I say, career cushioning sort of pertains to those who are taking maybe more proactive steps in looking for other work, given that they're fearful of losing maybe the job they have right now. And some people have been coming to me and asking me whether or not you can be penalized or punished for looking for another job while you have one going on at the moment. And the general answer to that is no, you cannot be. Now, you can't, or at least you shouldn't, be looking for another job while you're on the clock with another employer. That's not going to be permitted, and that could cause some complications for sure. But as far as generally looking for another job, especially if you're doing it after hours on your own time, as I say, your employer is not going to be able to punish you for doing that. They may not necessarily be thrilled if they find out about it, and they may in fact let you go, but that's not going to prevent them from having to pay what they're obligated to pay in your circumstances, which, as I mentioned at the top of the show, could be upwards of 2 years of severance. So if you're also someone in a situation where maybe you are looking for work and your employer is aware of it and is causing trouble for you, you definitely want to give us a shout as well, and we can kind of take you through that in addition to any other concerns you may have at the time. Having said that, I see that I've got a number of questions coming in today, so thanks for those of you who've got your questions in. And I'm going to start with Sunny through YouTube. Sunny is saying that their role involves keeping two partners updated. However, one of them has been showcasing or exhibiting some rude and harassing behavior towards Sunny. Sunny's spoken to the partner about it and informed that partner that Sunny, he or she, will no longer be communicating with that person and will only communicate with the other partner. And Sunny's asking whether or not there's any legal consequence for this request. And Sunny, I would say in general, employers have an obligation to keep the workplace safe and, of course, free of conflict. And this is just a general obligation that extends to most, if not all, employers. So if you're having to deal with a coworker who is, in fact, being rude towards you, who is exhibiting harassing behavior, harassment-like behavior, generally speaking, the first thing I always say is that you're going to want to advise someone within the company about what you're experiencing, so that, first of all, the company knows, is aware of it, and it's not being isolated to just you and this other individual. And then later on, the company won't have the ability necessarily to say that they didn't know about this. So that's number one. And secondly, as I mentioned, companies have an obligation to address concerns like these and ensure a free and safe kind of work environment, free of any kind of concerns along these lines. So if after being told about the issue, the company does not take steps to try and rectify it, then that could be an issue for the company. And Sunny, that may give you more options, or at least an ability to possibly exit the situation and receive some form of compensation. But I think it does start with raising the concerns you have to the appropriate person, whether that's HR or someone else that might be set out in a policy somewhere. Finding out what, if anything, the company is or can do to accommodate the issue. Sometimes the company may respond by saying that, like you've done, you won't communicate with that person going forward, and you may only communicate through other channels. Other times the company may, relocate somebody, assuming it's consensual, to another area or another part of the company, so that you're not having to cross paths with that person. So there should be some form of accommodation being offered by the employer. If the company itself is demanding that you talk to somebody who has in the past harassed you or bullied you or has been rude to you, then the question in my mind would be, why is it that the company can't accommodate? Is it because it's a requirement of your job to talk to this person or to communicate with this person? Well, in that case, there should be some backup person, in that area that can help you out. But if it's literally you have to talk to this person or not, then I think it's going to come down to some of the more specifics about your job. That may lead to you leaving the job and getting severance or getting some compensation, but it's hard to speak any further on it, Sunny, only for the lack of detail. So I think this would be a situation where you'd want to give us a call and let us know, maybe so we can flesh out the situation a bit more and find out what can be done. But as I say, there should be an effort to accommodate, and assuming that accommodation can happen and you can still perform the gist of your job, the full responsibilities and duties of your job, then that should be the case. And if they don't do that, then it's going to really come down to why is it they can't accommodate you? Because, as I say, that could be an issue for the company and actually potentially entitle you to some significant damages. I've got another question in from Tanya on YouTube as well. And Tanya is asking whether or not the Labor Relations Board helps out with just work issues more generally, or just union issues specifically. And Tanya, my understanding is that the Labor Relations Board is primarily union focused. However, if you are an employee who is looking for other help through the government, I know you can contact the Ministry of Labor. They may be able to potentially offer you some further guidance when it comes to more general work issues. But in terms of union specific issues, yes, the Labor Relations Board does deal with that. And if you're an employee and you're in a union and you have union related issues, the other place to check out, of course, would be to talk to your local union rep or consult the collective bargaining agreement that would, I guess, apply to the union that you're a member of and the company that you work for. But thank you for your question, Tanya. I've got another question in from a Google user who is saying that a union employee is moved from a union role into a non-union role, and the non-union role has a 3-month probationary period clause, and the employee has agreed to it in writing. And now management wants to terminate this employee's employment, I guess, during this probationary period clause and transfer the employee back to the union role. And they're asking whether or not this is allowed. So I will start just by saying that I don't specialize, nor does my firm specialize in unionized matters. So take, of course, what I have to say with a grain of salt. Again, I'll say for those that are unionized and you're looking for answers to some of these questions, a good starting point is going to be your union rep or the collective bargaining agreement. Now, in this particular situation, the question revolves around whether or not a non-unionized member can be transferred back into a unionized role. And to that, I would say, generally speaking, most things are possible if the union is willing to accept this employee back, and there isn't any provision or any kind of a contract that would prevent that from happening per se. Then it doesn't strike me as being an issue, considering that they were moved to the non-unionized role earlier. Now, a question would be whether or not their years of service and their tenure under both the union and non-unionized roles will be considered throughout, but that may be a potential option. I don't know if this employee wants to go back to the union role, but there might be another situation where if the non-unionized employee refuses to go back to the union role, that there may be some difficulties there or an inability to do that if the employee has already agreed to a non-unionized role with a probationary period clause. So I think if the union employee or the non-unionized employee was okay with going back to the union, it seems to me that might be something possible. But if they wanted to refuse that and remain in the non-unionized role, well, then to that, I can say that they're not going to be able to control that. The employer, if they want to let that person go from the non-unionized role, are within their rights to do so. And at that point, it may become a matter of finding out just how much severance that person is owed. And again, that might include counting in both the previous unionized tenure and the non-unionized tenure. So even if it was a 3-month probationary period clause, they may very well, in fact, be treated like a 3, 4, 5, 6, 7-year employee and not just somebody with 3 months. So I think this is another question that is best served by giving us a call. We can get some more details. To the extent that we can offer assistance, especially when it comes to the non-unionized aspect of the issue, we'll certainly do so. And if there's more union-specific questions, then, if anything, we can redirect those questions to, as I say, a local union rep or perhaps somebody over there who was dealing with that employee before when they were in that union. So thank you, though, again, as well for your question. I've got another one in from Jay on YouTube. And Jay is saying that they were laid off by a company due to the company losing contracts. So presumably a business related reason, lost the contracts, and now are getting laid off and or terminated. It's not all that uncommon. Jay's mentioning that there was other work offered that is much different from what Jay did. And Jay's wondering if there's any way of trying the other work while ensuring that they don't lose the severance in the event that the position is not for them. So, Jay, first of all, I assume that when you say laid off by a company, you mean that you were terminated and that you were offered severance. And so normally when somebody is terminated and offered severance, there's a general obligation on that person to go out and try and find comparable work. So if you, for example, lose your job and you're making $50,000 and you get another job offered to you that's only paying 25, you're not obligated to accept that job. You can sort of refuse that job and continue looking for comparable work. Or perhaps you've lost your job and you're offered severance and you're given a job that pays the same amount of money, but it's a completely different job. So maybe you're at one point a call center person, and now you're being considered for a job, walking dogs or something. Just the nature of it, the point being the nature of it's very different. If you take on that job that's very different after having received or been offered a severance package, then you may not be able to get the same severance package that was offered initially. So if you lose your job, you're offered a severance package, and then the employer who offered you the severance finds out that you're doing other work in some other capacity, they may no longer be willing to offer it as what they offered initially. So I would say, Jay, that before you accept any job or any job offer, again, you'll want to give us a call, because it may be that what's in your best interest is to resolve the severance issue with the first employer and then move on to a potential second employer. You just don't want to necessarily be doing something that may be beneficial for your life in terms of getting a new job and earning income, but then may not be beneficial in terms of any kind of case you have against the first employer, or in terms of any severance rights that you might get. You're still going to generally get certain bare minimums of severance, but someone finding a job and working that job could put that severance, or at least a portion of that severance, in jeopardy. So you want to give us a call before you do that, so we can kind of manage that in the best way possible. I've got another question in from Bubba on YouTube, who is saying that they're a seasonal worker, and the place that they work, they have to send their resume and cover letter every year. And Bubba's asking whether or not they should be getting severance since they have to reapply. So one question, Bubba, would be, just because you're a statement, I guess, would be, just because you're a seasonal worker that works, let's say, every spring, summer, and fall, but then you take the winters off, doesn't mean that if you do this for several years, you're not going to be viewed as a longer service employee. So for example, Bubba, you could work every season except for fall for the same company for 10 years straight, and odds are you're going to be considered an employee, a seasonal employee of that employer for 10 years straight. And if the employer decides to not offer you a job in the 11th year, the 11th season, then I would argue that you're actually entitled to severance that would befit somebody with 10 years of service. So just the fact that somebody's a seasonal worker and maybe they either laid off for a portion of the year or don't work for a portion of the year does not mean that they're considered a new employee each and every one of those years. So, Bub, I would say that if you are in the situation where you've worked for several years, even though you've had to submit your resume and cover letter each year, you could be racking up that seniority, so that if that ever were to stop, full stop, you would be looking at something that would be applicable to an employee with several years of employment, and not just getting judged on a year-to-year basis as a year-long employee each year. There may be additional details, Bubba, with respect to your question. And I think, knowing things like how long you've been there and what, these resumes and cover letters say, and whether or not you're having to go through a formal job application process or an interview, whether you're having to sign new contracts each and every year. A lot of these things may influence what your options are. But I just want to reiterate that the main point I think I'm trying to get across right now is that seasonal employees can be treated the same way as your standard, year-round employee when it comes to severance. But if you want to talk a little bit further, Bubba, by all means, give us a shout and we can talk through it a little bit more. I've got a question from Drew on YouTube. Drew's asking whether or not U.S. and Canada laws are similar when it comes to employment. And Drew, while I will say that I'm not a U.S. lawyer and I have no knowledge of U.S. law specifically, generally speaking, U.S. and Canadian laws differ very much. And so if you're being told that you're only owed a certain amount of money under U.S. law, absolutely don't assume that that's the case with Canadian law. And in fact, in a lot of cases, the Canadian laws are much more beneficial, much more advantageous to employees than US law. It is really, though, like comparing apples and oranges. So, but I can say that they're very different in that respect. So thank you for your question, though. I've got another one in from Belinda on YouTube. Belinda is saying that a new manager recently started at her company and is looking to make a number of changes to the scope of Belinda's work and changing her job entirely. And Belinda's asking whether or not they have to accept these changes. And Belinda, anytime an employer makes significant changes to the terms of your employment that you do not agree with, that you have not consented to, you generally have an option. You can either accept the changes and move forward, knowing that those may well now be the changes going forward. You can try to negotiate perhaps a lighter amount of change, a lesser amount of change, and do that going forward. Or you can tell your employer that that's not what you signed up to do, that this is a significant change to the job, and that you do not agree with that change. You'd want to say something along the lines of you're ready, willing, and able to work the job you did sign up to do, but that, again, the clear point being you don't agree to these big changes. At that point, the ball will then be in the company's court, and they will have to decide whether or not they just come back and tell you, well, too bad, so sad. That's the way it's going to be. So that's what you have to accept, in which case you could be in a position where you can leave almost as though you're quitting in a way and get severance. Or the company's going to come back and maybe, say, let bygones be bygones, forget about it, go about doing the job that we signed you up to do. Belinda, though, I will say that I would want you to give us a call first, just because the communication you have with your employer now that something like this has happened, I think is going to be pretty important. You're not going to want to say anything that could do damage. But what I've said does give you a general outline of your potential options in that scenario. So you want to give us a call and we can talk you through it and let you know, what your options are. If you have the ability to walk away, essentially, depending on how long you've been there and your age and how much money you're making in the position, your severance entitlements in that scenario might be also very significant, which may then make you want to go in that direction. Or we can talk about the best way to try and keep your job, the one that you signed up to do, and not have these changes get enforced to the nature of the job itself. But thanks as well for your question, Belinda. I've got another question in from Linda. Linda is asking or saying that their employer was providing medical accommodation for a condition that they're struggling with, which is good. Employers do typically have an obligation to accommodate, especially when it comes to medical issues. And Linda's doctor recently determined that she would need a permanent accommodation, and the employer has refused this and removed all accommodations that were previously in place. And Linda's asking whether or not they can do this. So, as I said, if somebody's got a medical condition that can be accommodated and they can still perhaps perform their job, or maybe they need to be accommodated by taking some time off before they can come back, then yes, employers have that obligation to do that. Now, this employer has been told that the accommodation needs to be permanent, and the employer then sort of had a change of heart, it seems like, and removed even the previous accommodations. So immediately, to me, that can signal discrimination. That can signal a failure to accommodate on the employer's side. And that can open up a whole can of worms then when it comes to possible compensation or damages that you would be owed for that bad faith and for that failure to accommodate. Not to mention that you could then also be looking at severance on top of all those human right or bad faith related damages. Now, there are some scenarios where employers do not have to accommodate anything that the employee asks for, but the employer has to really prove that there's been a lot of hardship in trying to accommodate that request. So until an employer can prove this extreme level of hardship by accommodating someone's request, it can't simply say it's an inconvenience and we're not doing it. That's what really gets employers into hot water. And because it's so rare that an employer will be able to show it's a really big hardship on them, anytime I hear a story about somebody who's not being accommodated, as I said before, there's alarm bells ringing in my head. And I think that there's a very good chance that your options could include potentially large severance package and human rights damages and the whole gamut. So Linda, that's another question you want to give us a call about so that we can kind of go into some of those details, figure out exactly what the accommodation request is, how a permanent accommodation would differ from a temporary accommodation, just going back to how it might impact the employer. And then we can, more properly advise you as to the situation and hopefully get what's fair and owing to you, or at the very least, or if that's what you want, to just keep you in that job with that accommodation. But thank you for that. That's, I think, an important one that a lot of people need to know about. I've got another I've got another question from Tanya on YouTube, who's asking whether or not being off work due to a work injury prevents you from being eligible from FMLA. And so, Tanya, I can say that there are some overlap there because you will get, I guess, if you're off work injury due to an injury, you will get either EI sick benefits or you will get, some sick benefits through the employer. But I think when you say FMLA, and correct me if I'm wrong, Tanya, but you may be referring to the Family and Medical Leave Act, which is an American statute or piece of legislation. But when it comes to Canada, because I can only speak to Canadian law, if somebody's off work due to a work injury and they're looking for government assistance, then they can typically apply through EI to get sick benefits. Or, as I said before, if their employer has a sick policy that speaks to, what can be given to somebody who's off work due to a work injury, then you can apply for the benefits through the employer, because sometimes those benefits are a bit more beneficial than the ones afforded by the government, by EI. I've got another question from Rick on YouTube, who's asking or saying that they're working on a contract as a manager for 6 years as a full-time job, and Rick was terminated and is saying that they're owed back wages. And Rick is asking as to the rights in the situation, whether Rick's owed severance. So, yep, if you are on a contract, Rick, first of all, the question is, what does the contract say? And this is just a question in general. Anytime somebody wants to know how much severance they're owed, it's possible that they may have signed a contract that limits their rights in some way, or it's possible that, at least the contract speaks to what happens in the event that they're terminated. So you kind of want to look at that always in the first instance to figure out whether or not any contract you may have signed affects your case. But, again, generally speaking, if somebody's working full-time for 6 years on a contract of some sort and they're let go, the probability is very high that they're going to be owed severance. And it seems like in Rick's case, they're also owed back wages. So that would be another item to include in the negotiations, in the request. That would be money that's already owed. So there really shouldn't be any contention with a request like that. But it could be a two-parter. So again, Rick, you want to give us a call. We'll have a look at the contract. We'll have a look at what the back wages owed are. We'll look into whether or not their failure to pay you these back wages amounts to bad faith, and whether or not, in addition to severance, which I think you would be owed from the sounds of it, whether or not you're actually entitled to further damages for failure to pay back wages, which could be easily viewed as bad faith. I've got one more question I'll get to before I sign off for the day, and this is from Merlin on YouTube. Merlin was issued a termination of severance by their employer and was duped into signing a voluntary resignation form. And Merlin's asking if there's anything he or she can do about this. And so this, strikes immediately as being a bad faith scenario, being duped or tricked into signing something that says you resign after what it seems like a clear termination has occurred. And unfortunately, I've seen this a few times in my experience where somebody's employment ended and they were offered a letter to sign saying they've resigned in exchange for a little bit of money, and not knowing their rights or what this meant, they signed it under pressure, as I say, not appreciating the rights otherwise. So what I will say is that sometimes when a form is signed, it can pose issues, whether we're talking about a contract, a resignation letter. that can pose issues anytime you sign something, even if it is in bad faith, even if you are being put under pressure, because it's not always clear what the circumstances were, and a lot of employers are going to say that it was signed voluntarily, that there was no duress, there was no pressure, nobody was tricked into doing it. So if you're ever in a situation, whether it's Merlin or anyone else, that's being pressured to sign something, definitely say you don't want to sign it. You need to review your options. You need to speak to somebody before you do so. And if unfortunately you do get tricked into signing a voluntary resignation form, then there are ways that you can get around that as well. You're going to have to clearly show that it was forced. It wasn't something you agreed to. But you shouldn't think, Merlin, that just because you were duped into signing something that therefore you have no rights. There's a very, very high chance you do. It's clear that there is bad faith in this case, plus severance. So I think your employer is going to have a lot to think about if they want to stick to this idea or argument that you've resigned, when in fact they could have just opened up a can of worms and are now exposed to paying you way more severance and money than they would have had they just terminated you in good faith and offered you a fair package. So definitely give us a call, Merlin. But on that point, I'm going to let you guys go. I thank you for all your questions. As always, I'll be back again, so I'll be happy to answer any questions when I return. But as you see there below, we've got another session going on tomorrow, live at 10 a.m. This time it'll be a disability law Q&A. So if any of you have questions relating to short-term disability benefits, long-term disability benefits, maybe you're in a fight with the insurance company or your employer, maybe you're getting denied disability when you have clear medical evidence to the contrary, these and many more are questions that Martin at our firm will be able to answer. So definitely tune in for them. But as far as I go, that's my time today. So thanks again, everyone, for your questions. I will be back. But until then, do take care. Enjoy the rest of your day.